What's up, everybody? Welcome in to something everybody was asking yesterday. We didn't have time to cover it in the video with my dad, but we are going to cover it today. The impoundment order filed by Judge Cannoni in the Karen Reed case. We're going to read that order. We're going to read the rule, figure out if we think it was necessary, how long it's going to be in place for, and could it be extended or potentially shortened? Are the names already known by the people involved that could potentially be an issue in the case? And we're going to look at Michael Proctor's update, the fact that he has been suspended without pay, how that happened, what it looks like, what the other potential outcomes could have been, and if that's the end of the Michael Proctor saga or if there is still more to come. So make sure you guys hit the like button on the video. Make sure you subscribe to our page. Let's get into it. All right, so first up is this order. We're going to read the thing in its entirety, and then we're going to read the rule that the judge cites here and why she does it. So the Supreme Judicial Court has recognized that the safety of jurors is crucial to their fair functioning of the judicial system, and that the justice system owes them the highest degree of vigilance for their personal safety. Everybody agrees there. This case has garnered significant and divisive attention in Massachusetts and across the nation. The trial was live streamed on local and national broadcasting channels. The proceedings continue to be the daily subject of commentary on various social media platforms. People associated with this case have been charged with intimidation. So starting just with these first two paragraphs, obviously we agree with paragraph 1, but we also agree with paragraph 2. And that it has absolutely been garnering significant and divisive attention. I feel like it's the most divisive case we've seen. Now, some people disagree with me. Some people agree with me. From the comments I'm getting on certain platforms, it's by far the most divisive. And people think, somebody's in the bag for this side or that side, or being accused of it from both sides, and they've been nasty about it. And guess what? That affects the process. The nastier and more divisive people are on social media and public platforms, the less likely you're going to get more access to a case, the less likely for a fair and just result. So instead, you can talk about it, you can give it attention, you can give your opinion respectfully, like we talk about in the chat all the time. That does not hurt the process. That can actually help the process. That can actually further positive change and positive change for justice and making the system better. That can happen. But when people are jerks about it and people are making threats and people are being horrible about it, it doesn't usually help the system. It really doesn't. Public outrage can be very good. It can be very positive, but it can also be very negative. Now, people associated with the case have been charged with intimidation. There's some interesting aspects to this, right? I think there have been multiple people that have been charged with this type of crime and comments made about certain people. Some of it may be very legitimate. Some of it may not be legitimate. But I think the important word here is charged with intimidation. Anybody that is intimidating a witness or a victim or a criminal defendant in a case, I unequivocally disagree with that. I unequivocally have a problem with that. Nobody should be intimidating or trying to affect anybody involved in a case because they just happen to be a witness, a victim, or a criminal defendant. I am fine with people calling out, I don't think this is true. I think there's some evidence that proves the Google search was at this time. I think Karen Reed was there or here or did it because of this reason. Or I think it couldn't have been Karen Reed because of what an expert says. That stuff's all fair game. And I don't consider that witness intimidation. Disagreeing with somebody or thinking a witness is not telling the truth, that's literally what a jury has to do. A jury has to determine whether a witness is credible. They're not intimidating that witness. They're determining whether they're credible. Now, threatening people's lives or threatening to show up at somebody's house or doing something at people's houses that is, not peaceful, that is threatening or physical or even likely to be carried out, physically touching somebody else, those are all problematic. And there are crimes and criminal statutes in place to prevent that. People have been charged. If people are convicted, that's going to take it to another level. That's going to be another big step. But here's another really important factor to consider here, just in paragraph 2. Because what do we know about this case? What do we know about this trial? How did it end? It ended in a mistrial. What's the next step? A retrial. Now, there is a court order, and the court has made a finding that there is significant and divisive attention in Massachusetts and across the nation. The trial was live streamed. Proceedings continue to be the subject of commentary, and people involved have been charged with intimidation. And we can add on and tack on here that there's an affidavit filed by an officer of the court, the defense lawyers in this case, that some jurors felt intimidated by some people on the Commonwealth side. I think the witness intimidation is the people on the defense side. And there have been accusations now on both sides of potential intimidation and influence on the jury or other witnesses. So with all that being said, I think this is probably an appropriate measure taken by the court, but I think it also makes us look at a potential venue change. Is this so divisive? Are people too intimately involved in the local community to make it impossible to impanel a fair jury for round 2? I think it's a legitimate question. I don't know which side's going to ask for it. I think there's arguments that either side could ask for it. The defense, with law enforcement, local law enforcement, everybody connected to everybody potentially. And we have a situation where they may think everybody's connected to the Alberts or the McCabe's or the Commonwealth in this local community. But on the other hand, I think the Commonwealth may have a legitimate argument that kind of the local community and even extended to the nation, maybe there's some kind of free Karen Reed movement that is gaining momentum that they don't think is going to provide an opportunity for them to get a fair jury in this location. But is that going to change if they change venue? Because it does say across Massachusetts and across the country. So where do we find a fair venue? And would the Commonwealth rather just take their chances in the venue where everybody knows each other? How many witnesses grew up in Canton, went to school with this person, public school with that person? Maybe they think that's some kind of benefit to them. All right, so let's keep reading. The court acknowledges that the names of the impaneled jurors who rendered a verdict in a criminal case must be retained in the court file and made available to the public, generally speaking. The jury in this case did not render a verdict. However, the court concludes that there is a real and present risk of personal harm to the jurors and to the integrity of their service. So what does that mean? Obviously, threats of physical harm. That's what the judge is worried about. Number one. But number two, threats to the integrity of their service. Well, their service is over, right? So what does that mean? I think what the court is saying here, and I would agree with, is we don't want the integrity of the service they've already provided to be damaged and changed. Will pressure from outside sources, will threats, will money make them change and say something that they didn't do during their service? Will they say I voted not guilty? Will they say I voted guilty? Will they say there was a split, there wasn't a split, unanimous on this, not unanimous on that? Will that start to change because of outside intimidation and outside pressure? That's the integrity of their service, even past service. And is this an indication that the judge is going to allow further investigation, further communication, and inquiry of the jury? Consequently, the court finds that good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. The court further concludes that there is a risk of immediate and irreparable injury should this list be made available to the public at this time. Now, that can mean physical injury or, like I said, changing of their testimony or what happened in the deliberation, changing of their position. Did they read all these comments and people breaking down the case online and where certain people would have voted if they don't agree with that, but they respect or like that person? And now they're saying, oh crap, maybe I did the wrong thing, I'm going to change. That's immediate and irreparable harm. Uniform Rules of Impoundment Rule 3A, which we're going to read. And the judge is using very specific language. She finds that there is a risk of immediate and irreparable injury or harm. Now, here again, this is an important aspect. The order shall expire 10 days from the date of the issuance, which is July 8th. So that means it would expire on July 18th, unless otherwise ordered by the court for good cause shown pursuant to Rule 3B of the Uniform Rules of Impoundment. We're going to read the entire rule. It's not very long, at least with what it has to do with this impoundment. So 10 days. Why? We'll get an idea when we read the rule. But a secondary, just interesting aspect, just again, commenting on it, this is no guarantee, but are we going to have some answers within the next 10 days? Is the judge going to rule? Is the state going to respond? Are we going to hear that there is going to be a jury inquiry? And if not, how long is she going to impound these names? If she's not going to do any further investigation, I don't see why any irreparable harm is going to be done. They're not going to change their comments or do anything to affect the case if she's just going to flat out deny the defense's motion and not allow any further investigation. So this kind of makes me think further investigation is coming, which again, I think would be the right decision. We want to get to the bottom of this. We want truth. We want justice. If there's going to be a retrial, we only want it on the charges or counts that the jury didn't already decide, as we broke down in detail in the last video we did yesterday. So now let's jump over to the rule and discuss this rule in Massachusetts, how and why it's handled this way. Uniform Rules on Impoundment Procedure. Motion and how allowed. An ex parte, which just in this situation means the judge did it on her own. You guys can't see, so let me change the view. There we go. Ex parte order of impoundment may be issued by the court without prior notice, so she didn't have to give everybody notice and opportunity to be heard, only upon either the filing of a written motion supported by an affidavit in the manner provided in URIP Rule 2, or by the court sua sponte, which happened here, and only upon a showing that immediate and irreparable injury may result before a party or interested non-party, which would be a juror, can be heard in opposition. The court may conduct an ex parte hearing prior to issuing an order. So I don't know, maybe they've had some secret ex parte hearing we don't know about publicly, but at this point, she has made a finding or a showing that immediate and irreparable injury may result if she does not impound the list of juror names. Limited duration of ex parte impoundment. This is the paragraph she cited when she said that it was going to stay in place for 10 days. An ex parte order of impoundment shall include the date of issuance, and the clerk shall record the filing of the order on the docket and store the order with the underlying materials. An ex parte order of impoundment shall expire 10 days from the date of issuance. So that's the date they put in there. You can't just do this forever. You really can't just do this forever. But you have to put a date range. You could say 5 days, you could say 1 day, you could say 3 days, whatever you think is appropriate, or just kind of the general and standard is 10 days, which is what the judge ended up doing in this case, unless otherwise ordered by the court for good cause shown. So if the court or some party says, we need to extend this impoundment for 14 days, 21 days, indefinitely, I don't think indefinitely you can do. But if you can, extend it for good cause shown. Notice after the court has ruled on the ex parte motion for impoundment, the movement, unless the ruling was sua sponte by the court, shall serve a copy of the motion supporting affidavit and other related documents on the parties and any interested non-party. Again, this is if somebody asked for it and the court made a decision, but on this, the court just did it on her own. The court shall provide notice of the ex parte order or the sua sponte order and scheduling of any subsequent hearing. We don't know if there's a subsequent hearing at this point, but hopefully there is. The court has discretion to order that certain notice requirements be withheld for good cause shown. Motion to modify or terminate the ex parte impoundment order. Any party or interested party or non-party aggrieved by an ex parte order may file a written motion to vacate or modify the ex parte order. So now the defense or the Commonwealth or somebody involved could file a motion and say, whoa, 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 you can't do this. We need the names to be public. Any motion to modify or terminate the ex parte order shall be accompanied by a certificate of service. That notice has been provided to all parties, any interested party, and any other person named by the court. Okay, we're not going to get into search warrants. So that's where we're at. The judge did it according to the rule. I agree with it. I think there is a lot of pressure, a lot of attention, a lot of going on social media still now, a lot of interest. Everybody's watching. Everybody's got an opinion. It's divisive at times. Charges have been filed. Accusations have been made by both sides about intimidation, potentially. So in an abundance of caution, let's take a minute and pause, but also potentially creating some fodder for a motion to change venue if one or both or either side want to file that motion in the future. They may not, or they may. We don't know. So I think and hope this is something that's going to say, let's have the hearing we need to have within 10 days and get this ball rolling and get it all figured out before the juror's name become public. But it's also important to remember that this isn't a situation where the lawyers in the case don't know the witness or the juror names. They know the juror names. They have. So if they already shared the juror names with anybody, maybe even somebody involved in the case or that's reached out to the jurors, not on behalf of the lawyers, but on their own to try to get interviews or something like that, before this order, that could be very different unless the court told them not to do that at some point or ordered them not to, which, we haven't seen publicly. So it's possible people already know the names. It's possible the cat's already out of the bag. But they're not going to be made public as they usually are, at least for another 9 days, because it's July 9th now. Okay, and that brings us to the second part of the video, which is the Proctor update. So the headline here, Trooper Michael Proctor, lead investigator in Karen Reed case, suspended without pay. Massachusetts State Police Trooper Michael Proctor, the lead investigator in the case against Karen Reed, was suspended without pay following a duty hearing on Monday. Proctor's duty status hearing was held virtually on Monday at Massachusetts State Police headquarters in Framingham. The veteran trooper was relieved of duty just hours after the Reed trial ended last week with a hung jury. He was transferred out of the Norfolk County District Attorney's Office Detective Unit and into a Field Services Division in South Boston. Massachusetts State Police Colonel John Mon accepted the board's recommended suspension of Proctor on Monday, making it effective immediately. The length of the suspension was not immediately known. So at this point, suspended without pay after a hearing, things were presented at this hearing. I don't believe it was public. It's got to be more than just text messages, I would think. And he is suspended without pay, which is serious, right? Guy's got a family. He's got a life. Got to pay for that. The first one was done with pay. We don't want to take somebody's pay away if it's just accusations, if there's no meat to this, if there's no substance to these accusations or these problems or things that he's doing, and it doesn't need to be immediately done and taking his pay and affecting his life and his livelihood. We don't want to do that. So this is definitely a step up in the punishment, in the process, in the problems for Michael Proctor. And his boss basically is like, I accept. I think it's fair. I think you guys made the right decision. I'm not going to fight it. I'm not going to appeal it. Proctor may appeal it. So he remains ineligible to perform tasks of a state trooper. But is this the end of the road for Proctor? Is the saga over? Are we done? Or is there more coming? Well, the internal affairs investigation into Proctor's conduct is ongoing. This is something separate and parallel from that. That investigation ends with a report that will rule each allegation. Here's what the results are going to be. They're either going to be unfounded, exonerated, not sustained, or sustained. So unfounded meaning they didn't find anything that proved these allegations. Exonerated meaning they proved that they're wrong. It didn't happen. Not sustained, basically like not proven, or sustained, which means screwed. Then we know about the text messages. There were protests outside the police barracks. Outside the police barracks where Proctor was transferred, a group of Reed supporters protested hours after the Proctor was suspended Monday. It's not enough. He needs to be fired. His behavior is disgraceful. He does not protect and serve. I don't think he should have a job. I think he should have been let go. It's disgusting. The end could have been he got his job back. He could have been continued to be suspended with pay. He could have received restricted duties, or what seems to be the most harsh, suspended with pay. And the response from the Massachusetts State Police, I think I've been very clear. And I want to remain very clear. Misconduct in any way, shape, or form by the Massachusetts State Police will not be tolerated. I think I've said that I condemn Proctor's comments in the strongest terms possible. So again, he is only referencing the comments. I would think there's got to be more, but maybe it is just the comments, and they suspended him without pay for those comments. And when I say just the comments, I don't mean to belittle them in the slightest. They are not reflective of the Massachusetts State Police. That's not where we want to be as an organization. I believe we will certainly continue to monitor that as we are moving through the process of our internal affairs investigation. I just watched Batman, The Dark Knight last night. And it reminded me of Harvey Dent, who was in the internal affairs, and the cops there in Gotham had a name for him, Harvey Two-Faced Dent. So the people that do and handle internal affairs investigations are usually not in cahoots with the officers they're investigating. Usually the officers don't like them. They're digging in. They're potentially being unbiased and saying, you're wrong, you're losing your job, you're losing your pay, you're getting suspended, or you're right, you're good, we're clearing you. Now, it's not perfect, and it's not like that in every office, but these are not supposed to be people that are Proctor's buddies or on the group text that are investigating him. So we can hope it's a real and legitimate and unbiased and fair investigation. And then we already know about what Karen Reed's attorneys have said about Proctor. And by the way, the people protesting outside of the hearing and things like that and have opinions, it's twofold, right? They are potentially part of the community that Proctor is sworn to protect and serve. So how they feel about local law enforcement, about elected officials is important, and people should take that into consideration. But it also goes with what the judge said. There's a lot of public pressure. People are showing up at people's houses. We don't want that happening to jurors because, again, we've got to pick another jury in this case. When I say we, it's the proverbial we. As a nation who wants justice, Massachusetts, local communities, Karen Reed, the defense team, the Commonwealth, the prosecutor, the judge, everybody wants to be able to pick another jury. And if people are showing up outside people's houses of jurors, putting pressure, picketing, saying things, making their comments known, that could be an issue on either side. So let me know what you guys think in the comments. Don't forget to hit the like button. This is a recorded video. It's not a live. Most of the Karen Reed videos have been live. So let me know what you guys think of this format. It's a little bit shorter, not as much, frankly, to cover as we have in most lives. It's kind of a tack on from yesterday's video because I wasn't able to get to it with the timing that we had there. Hopefully you guys enjoyed it. Let me know what you think in the comments, as I'm sure you will. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.